and it's really a pleasure to be part of the UGS signature course program. And the American death penalty really occupies an odd position in at least two respects. The United States is the only economically advanced democratic country in the Western Hemisphere that retains the death penalty. Abolition has been virtually accomplished throughout Europe, North America, Central America, South America. And it's not just that the United States continues to have death penalty statutes on the books. The United States is also one of the leading executing states in the world, joining company with China, Iraq, Iran, Pakistan, and other such countries. So one puzzle is, why is the United States alone among Western democratic economic powerhouses in its retention of the death penalty? On the other hand, the American death penalty is extremely fragile at the current moment. It's an extraordinary decline. This decline has happened over the last 2 decades along numerous dimensions. The number of death sentences produced nationwide has just decreased exponentially from over 300 death sentences a year nationwide in the 1990s to fewer than 50 death sentences a year over the last several years. The number of executions nationwide, even though it remains high among the world, other countries in the world, has also declined extraordinarily from close to 100 executions a year in the late 1990s to about 24 or so executions a year nationwide. The number of states within the United States that retain the death penalty that number has declined significantly from over 40 states that have the death penalty relatively recently to the current day, where we only have 30 American states that have operable death penalty statutes on the books. And public support for the American death penalty has declined significantly as well over the last 20 years. So these two issues that I want to discuss tonight are, first, how did we get here? Why is the United States exceptional in its retention of the death penalty? And the second question is, will this withering of the death penalty in the United States lead the United States to join the rest of its Western democratic colleagues in abandoning the death penalty in the near future? So I'll start with the first issue of American exceptionalism. What is it about the United States that accounts for its outlier status in its retention of the death penalty? And the conventional wisdom is that there are two different kinds of theories that explain American exceptionalism. The first theory is a cultural explanation. The argument is the United States is different from a lot of its Western democratic peers in its very high rate of violent crime, its racial division, high rate of racial conflict, in its religious fundamentalism, which has been associated with death penalty retentionism, in its high levels of economic inequality and low levels of social solidarity. So one theory is that the United States is just culturally different from the states that abandon the death penalty, and advocates of this account would point to the fact that most of the executions today occur in places that had high rates of lynching 100 years ago. So the argument is the American death penalty is part of sort of the vigilante values that the United States had in an earlier era, and we continue to have that expression of sort of frontier values, racial conflict, and so on, that makes the United States different. The second argument doesn't focus so much on culture as political design. The United States, unlike most other countries, is a federal system in which criminal justice decisions are not made at the federal level for the whole country. Every state has its own criminal justice system. Every state has its own criminal justice code. It's not at all clear that Congress, even if were it to want to do so, whether Congress could abolish the death penalty nationwide. So the argument is American criminal justice is decentralized. And so the fact that there are some American states that retain the death penalty is just a feature of this decentralization. And some people would add to that that our politics tends to be more populist and less elite, so that for example, in Europe, when the death penalty was abolished in most of the countries in Europe, the public supported the death penalty, but parliamentary elites were able to abolish despite the sort of populism and the support for the death penalty. So that in the United States, we have a more populist, localist politics, and that death penalty retention is just a feature of that, so that 30 states have the death penalty, 20 states don't have the death penalty. The federal government has the death penalty, but it's a very small part of the American death penalty. So that argument is sort of a structural argument. I think both of these explanations have some power, but I think that they are both also significantly flawed and fail to capture exactly what's going on with American exceptionalism. So take first the cultural explanation. The cultural explanation focuses on the fact that the United States is different today from the rest of the Western democratic world in its retention, but it fails to capture the fact that for most of our history, the United States was an outlier in the opposite direction. The United States, when it was founded, had a number of leaders, including James Madison, Benjamin Franklin, Benjamin Rush, who were opposed to the death penalty. And the United States was at the forefront of restricting the death penalty in the late 18th century. The United States was at the forefront in actually achieving abolition. Some American states abolished the death penalty in the mid-19th century. Wisconsin, Michigan, Rhode Island abandoned the death penalty in the 1840s and 50s, well before almost any other jurisdictions in the world. And the United States was on a very similar path to Europe with respect to the death penalty in terms of narrowing the numbers of crimes that could be punished by death, in terms of trying to humanize execution methods by moving from hanging to electrocution to lethal gas and so on, in terms of moving executions from the public sphere into behind prison walls so that they weren't public spectacles. So if you looked at the long arc of American history, the United States looks a lot like Europe and other countries and other areas that have abandoned the death penalty, and the divergence is relatively recent. So there's something problematic about having a deep cultural explanation of why the United States retains the death penalty that only focuses on the divergence today, as opposed to the long period during which the United States looked a lot like the rest of the world that had the death penalty. The political explanation, the sort of American federalism structural explanation, is rooted in the idea that the United States lacks a sort of unifying political elite force that could accomplish abolition, and that the death penalty is just an issue for local politics outside of sort of any other area of control. The problem with that explanation is the United States came extremely close to abolishing the death penalty in the early 1970s. In the early 1970s, the United States Supreme Court struck down all prevailing capital statutes as they were then operating. And it's really almost a matter of chance and fortuity that the American death penalty revived after 1972. So the United States does have a mechanism that would override local populist support for the death penalty. That is the sort of counter-majoritarian United States Supreme Court. And if the United States Supreme Court had sort of adhered to its decision to abolish the death penalty in 1972, the United States would have been early compared to most of the rest of the world in abolishing the death penalty. In the mid-1970s, there were only about 24 jurisdictions in the world that had abolished the death penalty. Today, there are over 100 jurisdictions in the world that have formally abolished the death penalty, and another 50 or so jurisdictions that are viewed as de facto abolitionists because they don't actually operate a death penalty system. They don't actually have either death sentences or executions. So the political account that looks at the United States structure, I think, misses the important fact that the Supreme Court operates in our country much the way that insulated parliamentary politics operates in other parts of the world, and that could lead us to abolition in the future and could have led us to abolition at an earlier era. So I want to talk a little bit about how we came so close to abolishing the death penalty in 1972, and talk just a little bit about why the abolition in 1972 didn't stick. To do that, I want to talk a little bit about the broader history of the death penalty in the United States. For most of our history, the United States Supreme Court had virtually nothing to say about the death penalty. The chief protections in criminal prosecutions in the Bill of Rights, in the Fourth Amendment and the Fifth Amendment and the Sixth Amendment and the Eighth Amendment to the Constitution, those constitutional amendments were only understood through most of our constitutional history to limit the federal government and not to limit state governments. And so for most of our history, when folks who were facing the death penalty appealed to the Supreme Court just rejected the challenges out of hand. Just to give an illustration, in the late 19th century, there was a challenge to New York's decision to move from hanging to electrocution. There's an interesting backstory to that challenge. The challenge was actually arose because there was a raging fight between two of the leading industrialists of the age, Thomas Edison, who was advocating for his direct current, and Westinghouse, who was advocating for his alternating current as the source of electricity in the United States. And Thomas Edison thought it would be a real boon for his plug for the direct current if he could make the alternating current seem very dangerous. So even though he actually didn't support the death penalty, he encouraged New York to adopt electrocution and to use the alternating current as the way to administer it. And instead, and he actually wanted to call the process of killing someone through electricity being Westinghoused, so that people would associate the dangers of electrocution with Westinghouse's current. And it turns out that the only reason this case got to the Supreme Court is because Westinghouse was secretly financing an effort to not allow electrocution to go forward because he didn't want his electricity to be associated with electrocution. But in any case, the case gets before the United States Supreme Court, and the Supreme Court says the effort by a state to try to make executions more humane is not really a subject for constitutional regulation. It rejected the challenge. The inmate who raised that challenge was electrocuted. In fact, there was something of a botched execution. Took a very long time for him to be executed. And for those of you who are interested, Westinghouse eventually won the electricity market over Edison because the alternating current was a much more efficient use of electricity. Fast forward a few decades, there was a case in which a Louisiana teenager was sentenced to death, and they attempted to electrocute him, but the folks who were administering the electric chair, this was a time when, before Louisiana had brought all of the executions to the central prison, so they had an electric chair that went from county to county when there was an electrocution, and it was managed by one member of the prison staff as well as an inmate who apparently were drunk at the time that they were trying to execute this inmate, Willie Francis, and they applied the electricity to Willie Francis and he didn't die, and his lawyers said he shouldn't be subject to another attempt at electrocution, what he called being executed by installments. The case went up to the Supreme Court, and the Supreme Court said again, the Constitution really doesn't speak to this. Literally the language of the Supreme Court was, accidents happen for which no man is to blame, and the court rejected the constitutional challenge. The only time the court started to pay attention to the American death penalty was in cases involving manifest racial injustice. The United States experienced a wave of lynching in the 1890s, early 1900s, to the point that we had more lynchings in this country in just the decade of the 1890s than we have had executions in this country over the last half century. As lynchings started to diminish, they were replaced with very truncated short trials in which often where there was a mob at the courthouse, the mob would be reassured that if they let the trial go forward without a lynching, that the inmate or the defendant would be executed very quickly. And there were a number of cases where that happened. The Supreme Court started to pay attention. And in one of the most famous cases in American history, the case involving the Scottsboro boys, the Supreme Court for the first time imposed a constitutional regulation on the death penalty. The Scottsboro boys case was a case in which 9 African-American teenagers were falsely charged with raping 2 white women on a train. The trial judge, instead of giving any of them lawyers, appointed the whole bar of the county to represent them, with the effect that nobody actually represented them at trial. Their trials were very quick, within 6 or 7 days of the alleged offense. 8 of the 9 were sentenced to death. The case went up to the Supreme Court, and the Supreme Court said for the first time that in state trials, inmates who were on trial for their life, defendants who were on trial for their life, had a right to a lawyer. And that was the court's first foray into regulating the American death penalty. By the early 1960s, the Supreme Court was still faced with a system in which there were manifest irregularities in capital trials, particularly capital trials involving African-American defendants accused of either raping or murdering white victims. And in 1963, in a case that was very similar to the Scottsboro boy case, African-American defendant sentenced to death for the rape of a white woman, one of the justices of the Supreme Court said for the first time that the court should consider whether the death penalty was a constitutional punishment as applied to the crime of rape. In his original opinion, he wrote that he was very concerned about the racial discrimination in the administration of the death penalty for rape. Chief Justice Warren asked Justice Goldberg to take that reference to race out of his opinion, which he did. But all the opinion said is the court should hear the case of whether or not the death penalty is excessive as applied to the modern effort to attack the death penalty. And the leading group that was involved in that effort was the NAACP's Legal Defense Fund, whose charge was to address racial injustice. They looked at that opinion by the Supreme Court and recognized that the Supreme Court was concerned about racial discrimination in the administration of the death penalty. They embarked on what they called a moratorium strategy, that if they could bring executions in the United States to a halt for a certain period of time, they thought the United States would learn to live without the death penalty. They embarked on that strategy, raising all kinds of constitutional claims against the death penalty. And somewhat miraculously, the strategy worked. In 1967, executions in this country came to a full halt. And the Supreme Court then heard in 1972 the issue of whether or not the death penalty as it was presently administered was constitutional. The Supreme Court issued an opinion, which was a remarkable opinion. At the time, it was the longest opinion ever issued by the United States Supreme Court, hundreds of pages long. All 9 justices on the Supreme Court wrote their own opinion explaining how the case should be resolved. 5 of the justices, writing by themselves, each wrote that they thought that the death penalty as currently practiced was unconstitutional. 4 justices wrote that they thought it remained constitutional. The only thing the 5 justices in the majority could agree on was that the current administration of the death penalty for these defendants before the court rendered the death penalty unconstitutional. Many people thought that was the end of the American death penalty. The New York Times had a headline as big and as bold as when man walked on the moon just a couple of years earlier, declaring the end of the American death penalty. But there was a huge and immediate backlash to the decision, partly because it was a fractured court, 5-4, partly because there was not much of an agreement among the 5 justices in the majority about what was wrong with the death penalty, partly because we were living in a time of rising violent crime rates. We had very low rates of violent crime in the early 1960s. By the early 1970s, violent crime was rising tremendously. Partly it was the politicization of crime, which really in some ways begins in the 1960s with President Nixon and his Southern strategy of trying to peel away the Democratic voters from the South by focusing on wedge issues like the death penalty. So in the wake of that decision, a number of states passed new death penalty statutes. In 1976, the Supreme Court upheld a number of those statutes, and we embarked on what is now regarded as the modern era of the American death penalty. What I think most people fail to realize about the American death penalty is that what is truly exceptional about it is not simply that the United States has retained it, while most other, or all other Western democratic countries have rejected it, but that the United States has retained it with a heavy overlay of constitutional regulation. So for the last 40 years, the Supreme Court has created elaborate doctrines trying to regulate the circumstances under which the death penalty can be imposed. And that's actually created 2 different dynamics. And I call these sort of the short-term and the long-term dynamics. The short-term dynamic of the Supreme Court upholding the death penalty and then regulating it extensively was to make the American people much more comfortable with the death penalty than they would have been had the Supreme Court not gotten involved in the first place. In other words, the United States Supreme Court legitimated the American death penalty by putting its imprimatur on American capital practices, and the death penalty started to rise, even though it had, in the 1960s, it really had shriveled to an enormous extent. So many people think of this as sort of a backlash kind of circumstance, where if the Supreme Court had never gotten involved in regulating the American death penalty in the 1970s, it may have just died of its own weight. But because the Supreme Court told the states, you can't have it, and then told the states, you can have it if we regulate it, that actually generated more support, more enthusiasm for the death penalty than would otherwise have been the case. So in some ways, the United States Supreme Court, by coming close to ending the death penalty, actually probably salvaged the death penalty in the short term. And so the American death penalty starts to rise in the late 1970s and 80s and hits its absolute peak in the 1990s. The longer term effect of the Supreme Court's regulation of the death penalty, though, was to actually sow the seeds for, I think, the death penalty's demise. And the principal way in which the Supreme Court's regulation accomplished that is it now created all kinds of institutions that hadn't existed before that were armed against the death penalty. In the 1960s and 70s, there were no such people as death penalty lawyers, no people who focused professionally on litigating death penalty cases. But because of the Supreme Court's regulation, there now were capital trial lawyers, capital habeas units, capital mitigation specialists, people who focused on developing evidence for why the death penalty should be withheld. By regulating the capital process, they're creating this huge new apparatus surrounding the death penalty and institutional actors that then, in turn, made the administration of the death penalty much more expensive. In the 1970s, one of the principal reasons in favor of the death penalty was that it was cheaper to execute someone than it was to put them in prison for the rest of their life for a crime that was heinous. by the 1990s and going forward, the costs of capital punishment now far outstrip the costs of the non-capital system. The costs of capital trials are extraordinary in terms of how long it takes to pick a jury. You're guaranteed in most jurisdictions 2 lawyers to litigate the case. You're guaranteed investigators, mitigation specialists. If you're a non-capital defendant, you don't get a free lawyer in state habeas proceedings or federal habeas proceedings. If you're sentenced to death, all of that is required to be paid for by the state. And just to give you an illustration of just how astronomical the costs are of the current American death penalty, they did a study in California to try to compare the costs of using the death penalty versus the cost of imprisoning someone for life instead of executing them. And then they calculated all of the extra costs associated with the death penalty, and then they divided those costs by the actual number of executions in California, which has been quite small. Even though California sentenced a large number of people to death, they've only accomplished 13 executions in the modern era. So if you take all of those added expenses and you divide them by the 13 executions, the figure that the recent studies have landed on is that each execution in California cost approximately $250 million. That's the expense of the American death penalty. And I think that's the principal reason why the American death penalty is in free fall. I don't think it's because attitudes about the death penalty have wildly changed, although they have changed. But I think it's because most states realize that the cost of having the death penalty is not nearly worth the benefit that might be secured by those costs. So the regulation of the death penalty has also destabilized the death penalty in a number of other ways. By actually regulating the death penalty and setting sort of standards for what would make the death penalty non-arbitrary and accurate, there's now sort of an accountability of the American death penalty. And I think many people have been surprised by, for example, the numbers of people who've been exonerated from death row, people who've been found to be factually innocent of the crimes for which they were sentenced to death. A number of the justices on the Supreme Court who originally believed that the death penalty was constitutional have arrived at the conclusion that the project of regulating it hasn't been successful in actually producing an even-handed, non-discriminatory death penalty. In particular, since the new death penalty statutes were enacted after 1972, there have been a lot of studies about the racial aspects of the administration of the death penalty, and most of those studies have pointed to an alarming persistence of racial discrimination in the administration of the death penalty, particularly discrimination against minority victims. It's very rare for states to seek and obtain the death penalty in cases involving minority victims. The Supreme Court's jurisprudence around the death penalty has also opened up the possibility for challenging the death penalty as unconstitutional. The key phrase in the Constitution that is related to the death penalty is the Eighth Amendment, which prohibits the imposition of cruel and unusual punishments. Before the Supreme Court got involved in regulating the death penalty, the way in which it would decide whether a punishment was consistent with, was not cruel and unusual, was consistent with evolving standards of decency, would be to look at how many states had the death penalty, how frequently the death penalty was imposed. And if the death penalty was on the books and there were a number of executions, that was pretty much evidence that the death penalty was consistent with evolving standards. But as the Supreme Court has faced particular challenges to the death penalty, the use of the death penalty for the crime of rape, which the Supreme Court rejected in 1977, the use of the death penalty as applied to persons with intellectual disabilities, which the Supreme Court rejected in the early 2000s, the death penalty as applied to people who were under the age of 18 at the time of offense, which the Supreme Court rejected in 2005, the Supreme Court began to refine its methodology. And it said, in order to evaluate evolving standards of decency, we don't just look at whether there are statutes on the books. We don't just look at whether or not there are a number of death sentences being produced. We look at broader indicia of evolving standards, including expert opinion, religious opinion, world opinion, opinion polls. And these kinds of data, these data points, are increasingly pointing to a world in which the death penalty might be unconstitutional. And just a few years ago, Justice Breyer wrote a very lengthy dissent in a case that upheld lethal injection against a particular challenge. And Justice Breyer said, now it's time to revisit the decisions from the 1970s that found that the death penalty could be constitutionally imposed. And if you had asked me in 2015 or 16 when he wrote that opinion, how long will the American death penalty persist in the United States? My answer would have been not more than 10 or 15 years, because it became clear at that point that there were 4 justices on the court who were very troubled by the continued use of the death penalty. And in fact, if we had had President Clinton instead of President Trump appointing the replacements for Justice Scalia and Justice Kennedy, I think it would have been extremely likely that the death penalty would have been constitutionally abolished, making American exceptionalism no longer a prevailing practice. But now we certainly have the prospect that the Supreme Court will not, in the near term, abolish the death penalty, and I think it's likely that the death penalty will continue to wither. If you're opposed to the death penalty, you might ask whether or not it's preferable to have the practice on the ground continue to wither, as opposed to having the Supreme Court intervene. My own view, and I am an opponent of the death penalty, is I don't think that if the Supreme Court were to intervene and strike down the death penalty, I don't think we would have a backlash of the kind that we had in the early 1970s. The political dynamics are completely different today than they were then. The rest of the world has pretty much turned its back against the death penalty. The death penalty is no longer the sort of wedge issue that it was in the 1970s and 1980s. One difficulty that we have, I run a capital punishment program at the School of Law, is it's often very difficult to find outspoken proponents of the death penalty today. Most of the folks involved in law enforcement are either quiet supporters of the death penalty or quiet opponents of the death penalty, and it just doesn't have the same salience as a political issue that it did a few decades ago. I want to close by pointing out one other interesting aspect of the American death penalty that I think makes the United States exceptional. Around the rest of the world, the opposition to the death penalty today is rooted in a conception of human dignity. Opponents of the death penalty in Europe view the death penalty as a human rights issue. They view the death penalty as inconsistent with the powers that the state should hold. They view it as a form of torture. They view it as a form of absolute and total dominion of the state over a person. What's interesting is because of the way, our peculiar path of the Supreme Court's regulation of the death penalty, opposition to the death penalty in the United States is rarely rooted in that sort of human dignity, human rights frame. That argument was the primary argument throughout our early history, the anti-gallows society. It was probably the motivating argument in the 1960s for opponents of the death penalty who believed it was an improper, inhumane practice. But today, opponents of the death penalty, in part because the Supreme Court rejected that argument, focus much more on pragmatic, instrumental considerations, such as cost. So opponents of the death penalty often don't even call themselves abolitionists today, because it has too much of a morally fraught connotation of the same sort of abolition of slavery. And rather, they ask for the repeal of capital statutes, that it's the way to be smart on crime to get rid of the death penalty because it doesn't achieve much social benefit and it's extravagantly expensive. So the opposition to the death penalty in the United States is much more pragmatic and instrumental and less sort of morally absolutist. The reverse is true for the opposition to the death penalty, for the support of the death penalty. Around the rest of the world, the few states that actively execute justify the death penalty on the grounds that it's needed to keep order in the streets, to keep the population safe, that it helps deter crime. Very instrumental, pragmatic arguments. But that argument is no longer available in the United States because the death penalty has become such a minuscule part of our criminal justice system. We have somewhere between 15,000 and 18,000 homicides a year, and if you're answering those thousands and thousands of homicides with 40 or so death sentences and 20 or so executions, it's not plausible that the death penalty is serving as a deterrent or as something that's important in keeping us safe. So the current supporters of the death penalty in the United States focus mostly on the idea of retribution, that some crimes are so heinous, so terrible, that the only morally appropriate response to those offenses are to execute the offender. And so we've had this flip in which the opponents of the death penalty used to be quite morally absolutist and not very pragmatic, and the supporters of the death penalty were very pragmatic and hard-headed in arguing for deterrence, but now are arguing that the death penalty is necessary for this sort of broader retributive idea. My own view is that the death penalty in the United States will be abolished, and it'll be abolished by the United States Supreme Court. That's really the only way that it could be abolished in all jurisdictions, all of the states in the United States. And when the United States abolishes the death penalty, the momentum for that abolition will be many of the pragmatic concerns that have come up in response to the court's regulation of the death penalty. That being said, I think once abolition is achieved in this country, we will look back and remember our abolition in a quite different way. I think we will remember our abolition as sort of a blow for human liberty, an affirmation of human dignity, and we will join the rest of the world in viewing the death penalty as a human rights issue. Thank you very much.